Hail to legal warriors. In this video, I'm going to get back to the basics. We're going to talk about what is the roadmap to defending a criminal case. What should you expect if you're charged with a crime? What are the common steps in defending a criminal case? What are you going to have to go through? And how does an outcome usually happen? And finally, what happens after the outcome is over? If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find these useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. You know, we have new people join the firm all the time. As we grow, we need new people. And I'm pretty transparent. Sometimes it's hard to come up with more topics because I've been doing this for so long. And one of our newer employees recently suggested, hey, I'm learning what happens in each court case. Most people have never been through court. So how about a video that sort of breaks down the basics of what happens in each court hearing and what hearings we might expect in a criminal matter? I said, great idea. So I'm going to cover primarily a non-felony charge in this case. There's basically going to be two roadmaps that end at the same place, one for felonies and state cases, and one for non-felonies that are city cases. They're both going to end in the same place, but there's going to be a little wrinkle in there that controls timing. So let's start with a case that's a non-felony, like a domestic violence assault 4 or a DUI, and a case where we've got a court date right away, where we've actually been charged by a city officer, like City of Seattle, City of Linwood, City of Tacoma, any city. For the most part, the officer is going to file their charge directly into court, and we're going to have a court date right away, which is called an arraignment. The first court date that a defendant needs to go to for an actually charged case where there's a criminal complaint filed directly by the officer or by a prosecutor is called an arraignment. And an arraignment, it's something in the court rules. And if we ever are curious and you really want to deep dive, just look up the Washington State court rules and it'll sort of tell you what to expect at each one. But an arraignment, the court is to inform the defendant of what they're charged with. There's actually a complaint that there's a prosecutor that will say, do you want me to read the complaint charging you with assault 4, or do you want me to waive a reading of it? And most people will waive the reading. They don't want to hear every little word read into the record. And then the judge will tell the defendant what the maximum penalty is and what the minimum penalty is based upon the type of charge. So for a domestic violence charge, they might assault 4th degree. They might say the maximum penalty is $5,000 fine, 364 days in jail. This is in Washington State. And the minimum penalty would be a DNA test if we get convicted and loss of firearm rights if we get convicted. On a DUI charge, there's also going to be mandatory minimums that will include a certain amount of jail time if we're convicted. And the judge will vary what they're saying based upon what the breath test was and based upon how many prior DUIs within 7 years that the suspect has. For other types of charges, there's typically not mandatory minimums we need to worry about. There's a few exceptions, but typically not. So what's expected to happen at the arraignment is they're not going to let you plead guilty. Well, I want to plead guilty. I want it over with. Well, they're not going to let you plead guilty usually because they're not set up to take guilty pleas. That's a lot of paperwork. Court is busy. And also they want to make sure that you have an attorney so your rights are protected because the prosecutor isn't on your side. Remember that if they let you plead guilty, the prosecutor can recommend whatever they want now. There's no bargaining. There's no listening to your side. I know we might want to get it over with. We might think it's like a traffic ticket. We just go in and talk and pay a fine or not. That's not how it works for a crime. So a really good court won't let you plead guilty. They'll make you plead not guilty. Then what happens? Well, the prosecutor is going to tell the court what conditions of release they want to set on you for the case going forward. What does that mean, conditions of release? Well, the judge has a duty to protect the public. If they find probable cause, reason to believe a crime was committed, based upon paperwork filed by law enforcement, then the judge has to decide, well, what conditions should I set on this accused person to make sure, number one, they come back to court, and number two, the public is protected. So standard conditions in most cases would be don't commit any new crimes, get an attorney or talk to your attorney, come back for all your court dates, and keep your address updated with the court. Usually they're not going to make you stay in Washington State. There are a few counties and jurisdictions that do. If you have a good local attorney or an attorney that's in a big firm like ours, will probably be able to tell you what to expect. And that will be the standard conditions. Additionally, they might set extra conditions. If you have a really bad record or a really bad case, they might want bail. Take the defendant into custody, the prosecutor says, and make them post $10,000 bail because we need $10,000 with the court that will forfeit and keep if they either don't come back for court or they commit a new crime or violate a condition of release, right? They could do that. They could issue a no-contact order. Almost in all domestic violence cases, they're going to issue a no-contact order saying don't have contact with the alleged victim. Even if the alleged victim is in court and saying they are against a no-contact order, the court will still usually issue one to protect the alleged victim protect them from him or herself. Very frustrating. They could order an interlock if it's a DUI case. Some courts will order GPS monitoring, which I'm really against. There's a few courts that do that. I think it's burdensome given the cost. They could order alcohol devices. They can make you wear a scram device. There's all the stuff that could happen. Do you need an attorney for that court date? If you can get one, yes. If you can get one by the court date, get it by the court date. Most courts will have what I'm going to call an attorney of the day present to sort of help everybody get through things. Some smaller courts may not, but most bigger courts will have someone there to help because most people either, one, can't get an attorney that quickly, or two, simply can't afford an attorney because attorneys, especially good attorneys, they're in such high demand, they need to charge a certain amount to be able to do their business in a way where they can keep providing good results. So finally, at that arraignment, once you say not guilty, they're going to set some new court dates. Most of the time, they're going to set a pretrial date and a jury trial date. They might call it different things. They might call it confirmation. They might call it a fact finding if it's juvenile court. They're going to call it different things, but there's going to be multiple court dates set. The main thing you have to worry about is make sure that you either show up for your next court date, or if you have an attorney, you listen to their instructions about the next court date. So next court date, we're going to call it a pretrial. So what happens at a pretrial hearing? Well, 4, 6, or 8 weeks after that arraignment, you've got this pretrial hearing that comes up. The pretrial hearing is a hearing that's sort of for the attorneys, the prosecutor and the defense attorney, to realize the case exists, right? The prosecutor's got hundreds of cases. Your defense attorney may have dozens of cases, may have hundreds if they're a public defender. And they sort of have to be on a cadence where they keep coming up in court, otherwise they'll just sort of get lost in the shuffle. And so at a pretrial hearing, the court rules may allow your attorney to appear for you. Don't assume that. You want to assume that you need to show up, because if you're supposed to show up and you don't, you're going to get a warrant for your arrest. And then the police are going to come knock on your door and haul you off to jail and bring you to court. You don't want that. But at the pretrial hearing, usually the attorneys are going to talk informally, either before the hearing or during the hearing, about what direction is this case going. Now, between the arraignment and that pretrial hearing, hopefully discovery has been provided to your attorney. Discovery is the evidence that the city or the state has that they intend to use against you to prove whatever you're charged with. And the court rules say they have 3 weeks. The prosecution has 3 weeks from the arraignment to get that to your attorney. If they don't get it to your attorney, the remedy is not typically a dismissal. That would be nice. It's usually a continuance. And usually nowadays with body cams and stuff like that, the discovery sort of trickles in, right? It doesn't all come in at once, so cases just take even longer. But the most common outcome of a pretrial hearing is what? Another pretrial hearing. Most pretrial hearings get continued to another pretrial hearing, to another pretrial hearing. Now, they may keep moving the trial dates because oftentimes they need a backup trial date in case the defendant goes, I want my trial. Right? There needs to be a date there because there is something called speedy trial. And there's going to be enough pretrial hearings until there's some type of what I call resolution by agreement arranged. And that could, if there is a resolution by agreement, either a dismissal or a stipulated order of continuance or a plea, a reduction in charges, then that may be done at a pretrial hearing, or depending on the practice of the court, it may need to be set for a special calendar. That they might call it disposition calendar, they might call it a resolution calendar, they might call it a plea calendar, but talk to your attorney about that. So what if there is no resolution by agreement? Well, there could be a motion hearing set, which you may or may not need to attend, where the attorney is arguing legal issues, like no probable cause to arrest, or it was a bad stop, or a Napstad motion, which means, hey, even if everything is true in the report, it doesn't constitute a crime, stuff like that. Or it may get set for a trial. And hopefully your case doesn't get set for a trial, because that's when you're at the highest risk, because now you're letting 6 people decide whether or not you get to go home, right? Whether or not you're guilty or not. Now listen to your attorney. You might have a really good case, and might be a good trial case, but at least for non-felony matters, usually a resolution can be had, hopefully without a trial, because the system only allows for so many trials. So that's basically what you could expect. You could expect an arraignment, multiple pretrial hearings, which you may or may not need to appear at, hopefully a resolution by agreement, where you usually will need to appear, or a motion hearing or a trial. Are you ever going to see witnesses? Only at a motion hearing or at a trial. Occasionally at a resolution by agreement, if you have a plea, you might see an alleged victim show up and tell the court, what they want to see happen, but usually not. Now, somewhere in the middle, there could be a motion filed by an alleged victim to drop a no contact order, stuff like that, but this is the general pattern. Now, once the case is over, you may have other obligations to the court. If you have some type of agreement in the case, either a plea or an SOC or a deferred sentence or these different types of things, there may be affirmative things you still need to do. So you may need to meet with the court staff. They might call it probation. They might call it something else. Check with your attorney about what you need to do. Now, what's the wrinkle? I said there was 2 paths, right? Well, now let's say it's a felony case or a case that involves a law enforcement officer that has wider jurisdiction, like state patrol or a sheriff. Now, for the most part, the rule of thumb is those type of cases, felonies, or officers that have wide jurisdiction, they're not allowed to actually sign a complaint into court. There's got to be a prosecutor that does things, and that sort of slows things down. Remember, an arraignment is just for once we actually have an actual filed charge. It's so confusing. What's a filed charge? Some legal authority signs a criminal complaint, literally accusing you of a crime, and says the elements. I hereby accuse John Smith of assault in the 4th degree by having unwanted touching with victim Mr. X, right? And I further say that this Mr. X was a family or household member in violation of RCW such and such and such, signed by either the filing officer or an attorney that works for the prosecutor's office. That's a complaint. So if it's a felony, police just can't do that. They're not allowed. They can arrest. And if it's a county officer, for the most part, the prosecutors don't let them do that either, and it's got to be countersigned by a prosecutor. So then what happens, Lance? I still have a court date. Well, that court date, if you're not charged yet, is typically referred to as a first appearance. A first appearance functions like an arraignment, except that you're not taking a plea of not guilty or guilty because you're not formally charged. The court rules say that a court can maintain somebody in jail only for a limited amount of time without reviewing to see if there's justification for the arrest, right? Think about the law enforcement officers as the executive branch of government. They are accusing the citizen of a crime. Think about the court as the judicial branch of government, which is a check and balance against the executive branch. And so a court is supposed to look at, basically within one court day, we're not counting weekends, the justification for the arrest. And the officer will typically file a probable cause statement saying, here's why I arrested the defendant. That probable cause statement is missing. That defendant's going to get released immediately at the first appearance without conditions because the court has to find probable cause. Occasionally, the officer will do a bad job and they arrest for something that isn't criminal, and they'll get released without conditions. But 99% of the time, whatever the officer files is sufficient for the judicial branch, the court, to say, yes, if this is true, we don't get to argue against that point. If this is true, that would be a crime. And so now they look to the prosecutor, just like in an arraignment, and they say, what conditions do you want? And the prosecutor will say, I don't object to personal reconnaissance release, but I don't want any contact with the victim, I don't want any drinking, et cetera, et cetera. But Lance, my loved one got arrested and they got out without seeing the judge. Well, sometimes for non-felonies, a judge might come in on the weekend and do what people call paper court without court, and sort of set their own conditions and make their own decisions. And in my opinion, the reason why they do that is to get people out of the jail, right? The jails are full. Also, cities and people that use jails, they pay the jail for every day someone's in that jail, right? And so it's also economics to it. But you need to pay attention because when you get released, you're supposed to get some paperwork telling you what your release conditions are. And if you're in King County on a felony, they're going to tell you to come back to court, typically at 2:30 p.m. in a day or two to see if you're charged. If you're in Snohomish County, they're not even going to give you a court date. They're going to give you a piece of paper at the bottom that says if charges aren't filed by basically 2 days from then, typically, then all the conditions listed, the bail, the no contact, don't have crimes, those all, they say, are dismissed. So this is what's really confusing. I think I have 6 videos on this channel about when a probable cause arrest is dismissed, the case isn't dismissed. The court rules also say that that prosecutor has to file a criminal charge within 3 court days of an arrested but uncharged person, or the conditions have to be dismissed for due process. So in the office, I call that the prosecutor rush filing. If they rush file it to maintain the conditions, then you'll get a court date, you'll get summons for arraignment, and we're back to the other path that we started with, okay? If the prosecutor doesn't file a charge, the conditions will evaporate, but the case is not over. Now it's just in the normal prosecutor's queue or pileup, right? The prosecutor will have a different length of time that they typically take for each type of charge in each jurisdiction. We have a lot of cases, so, I tell people, King County, misdemeanor, I might expect 4 months till they get to it. Snohomish County, 6 months to 2 years. Cities really vary. And so at that point, you may or may not want to hire an attorney, but you're not out of the woods yet. You're only out of the woods when the statute of limitations runs, 2 years for most non-felonies, 3 years or more for most felonies. Some have no statute of limitations, certain types of really distasteful offenses, which YouTube won't let me talk about. But if the charge is filed, at some point, they're going to either tell you to go to court or you get a summons to go to court in the mail. Then we go back to square one with the arraignment. What happens if you're never filed? What happens if the statute of limitations runs? Can you delete your arrest? If nothing else has happened and no charge is ever filed, the current version of the law says you can delete your arrest record 3 years after the arrest date. Does deleting your arrest record make it invisible? Absolutely not. Private companies collect data. Private companies collect data. There's no statute that makes private companies erase their data. So just realize what most employers care about are convictions, not charges that were never filed or charges where you weren't convicted. So this was a very lengthy video compared to most, trying to give you an idea of what to expect. It's very low-key in court. You typically don't see the officers involved. You don't see the witnesses involved. You never even have to show identification. Unbelievable, right? You can walk into court and say you're Mr. Smith, and they just believe it, right? They don't say, show me your ID, Mr. Smith, when you're pleading guilty to a DUI. It's just, just how it works in Washington. So realize that everybody in court is more worried about their case than they are about your case, right? So the most important thing to do is, get qualified counsel that is, well-known and well-experienced in whatever general area you're at, right? Well, we're well-known and experienced in Western Washington. You wouldn't want to hire us for Spokane, right? Because, we're not going to be able to tell you exactly what to happen there. So that's what I could tell you. I hope it helps. If so, please like it, please subscribe. More people get to see it. More people get the help they need. More importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. We get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.